The first time I saw the survey stakes, I assumed they were a mistake. They were bright orange, hammered into the soft edge of my lower pasture, lined up with the kind of confidence only contractors carry. Perfect spacing street is a ruler, not something a bored teenager or lost hiker would do. I stood there at sunrise, boots wet with dew, looking out over land my grandfather bought after the war. Land that had been in my family longer than the county records bothered to remember, and I felt that slow, sinking weight in my chest that tells you something expensive is about to happen to you without your consent. That land wasn't just acreage. It was my childhood. It was fence post I helped set when I was 12. It was the creek where my dad taught me how to fish. It was the back 40 where my mother planted trees every time someone in the family died, as if roots could keep memory from drifting away. I owned it free and clear, no mortgage, no easements except a utility line that had been negotiated in the 1980s with paperwork thicker than a phone book. So when I followed the stakes downhill and saw the grading equipment parked just beyond the tree line, I didn't feel confused. I felt offended. Within a week, the answer arrived in my mailbox in the form of a glossy flyer. A master planned community, 96 homes. Gated entry, private walking trails. Luxury, living with pastoral charm. There was a rendering of houses that looked like they'd been copy-pasted from every other suburban development in the country, each one sitting neatly on what the flyer described as formerly unused. That was my land, all of it. I drove to the address listed for the developer that afternoon, a polished office with glass walls and a stone sign out front that looked like it had cost more than my pickup truck. Inside, a receptionist smiled the way people do when they assume you're about to be impressed. I told her my name. I told her why I was there. Her smile stiffened, just slightly, like a door being closed carefully instead of slammed. The project manager met me in a conference room and spoke in rehearsed sentences. He said the HOA had already secured the land through a valid deed transfer. He said construction was scheduled to begin immediately. He said any disputes could be handled by their legal department. He never once asked me if there had been a mistake. I went home and pulled every document I owned, deeds, surveys, tax records. The county map still showed my parcel exactly as it always had. I paid my property taxes on every inch. There was no recorded sale, no transfer, no easement that would allow residential construction. Nothing. That's when I made my first decision. I didn't stop them. I could have filed an injunction. I could have called the sheriff when the bulldozers rolled in. I could have made noise, raised hell, chained myself to a fence post if I wanted to. Instead, I called my attorney, slid copies of everything across his desk, and told him I wanted to watch. Because here's the thing most people don't understand about power. Loud people use it early. Smart people let the other side commit. Construction began in the spring. Trees came down in neat rows. Dirt was moved. Roads were cut. Foundations were poured. Every single day, heavy equipment crossed my land as if it had always belonged to them. I documented everything. Photos, videos, dates, contractor names, license plates. I didn't interfere. I waved politely when workers passed my fence line. Some even assumed I lived in the development and nodded back. The HOA board sent me one certified letter early on informing me that access to the construction site would require coordination through their office. I didn't respond. Silence is not consent, no matter how much they wish it were. By summer, framing was up. Houses multi like mushrooms. After rain, the sales office opened with balloons and banners. Prospective buyers walked model homes built squarely on my soil, listening to agents talk about clear title and long-term stability. I watched families point at kitchens, children run through empty living rooms, and I felt something like guilt try to take root. I killed it immediately. None of this was my doing. I had not lied. I had not misrepresented. I had not signed anything they had. My attorney filed nothing. He recorded everything. He said very little. Every month I paid my taxes as usual. The county accepted them without comment. The HOA paid nothing to me because they believed they already owned what they were using. By the time the first homes were finished, the board president decided to introduce himself. He showed up in a black SUV with tinted windows, dressed like someone who thought authority was something you wore. He complimented my land. He thanked me for being cooperative. He spoke about community harmony and future collaboration as if we were partners instead of strangers. Then he told me, casually, that once residents moved in, my remaining acreage would increase in value and that I should consider selling the rest to them at a fair rate. I smiled and said nothing. The law lawyers sent a letter shortly after, asserting ownership through a deed recorded years earlier as part of a land consolidation agreement. They attached a copy. It looked official at a glance, stamps, signatures, county, seal. It was also forged, not sloppy forged, careful forged, the kind of forge that relies on people assuming records are infallible. But paper has tells, ink ages differently. Signatures evolve, survey boundaries don't magically shift without leaving scars in the record. My attorney didn't respond. Fall came, the development filled in. 96 houses stood where my pasture used to roll. Streets were named, trees were replanted. The HOA installed a sign at the entrance, planted with flowers, sitting entirely on my land. Families moved in, cars filled driveways, life settled, and still I did nothing. The lawsuit came from them first. They filed for declaratory judgment, asking the court to affirm their ownership and quiet any potential claims. They expected me to either fold or negotiate. What they got instead was a counterclaim thick enough to thud when it hit the clerk's desk: trespass, fraud, unjust enrichment, clouded title, damages calculated per day, per structure, per occupied home. Discovery was brutal. Emails surfaced where board members discussed fast-tracking construction before that landowner figures it out. Internal memos admitted the deed had irregularities, but suggested proceeding anyway because the risk window is small. Contracts testified. They were told permits were in order. County officials admitted no one had cross-checked the consolidation filing because the HOA's attorney filing because the original deed on the evidence table. Not a copy, the original. Handwritten descriptions, surveyor marks, recorded, stamped, uncontested for decades. Then he laid out the timeline. Every day they built, every day they sold. Every day they occupied, all on land they never owned. The judge didn't rule that day. He didn't need to. The weight of it was already crushing. By the time the decision came down, winter had settled in. The ruling was precise, merciless, and entirely predictable to anyone who respects property law. The deed was invalid. The land was mine. Always had been. The homes. Built, sold, occupied. All sitting on land owned by someone who never gave permission. The courtroom emptied slowly. Faces pale, lawyers whispering. Board members staring straight ahead, like motion alone might undo what had been spoken into record. I didn't smile. This wasn't over. It was only finally beginning. And as I stepped out into the cold air, with the deed returned to my hands, I felt the woe grown beneath my boots the same way I always had. Solid, patient, waiting. The news traveled faster than I expected. By the next morning, my phone was vibrating non-stop. Local reporters, regional outlets, a national legal blog that specialized in land disputes. 96 homes built on land, the kind of story people loved because it sounded impossible, and because deep down, everyone enjoys watching confidence meet consequence. The HOA board called an emergency meeting that night. I know because one of the board member spouses called me, voice shaking, asking what I wanted. That question kept coming up over and over from different mouths, in different tones, always carrying the same fear underneath it. What do you want? The truth was simple. I wanted what was already mine. Nothing more, nothing less, and I wanted it acknowledged properly. In ink and enforceable terms, the HOA's attorneys filed a motion for a stay, trying to freeze enforcement of the judgment while they appealed. The judge denied it within 48 hours. Property rights are not theoretical. You don't get to pause reality just because you built something expensive on top of someone else's ground. That's when things started to get ugly. The HOA sent letters to homeowners first, framing the ruling as a temporary title clarification issue. They assured residents there was no immediate cause for concern, no risk to occupancy, no threat to their investment. That lasted about a week until my attorney recorded the judgment against every affected parcel. County records updated overnight. Banks noticed mortgage lenders don't like uncertainty. They liked clean chains of title and predictable collateral. Suddenly, 96 loans were backed by structures sitting on land owned by a third party who had never signed a ground lease. Refinancing froze. Home equity lines vanished. Pende resale collapsed mid-escrow. That's when residents started knocking on my door. At first, they came angry. They had been told I was a greedy landowner trying to extort the community. They accused me of ruining their lives, threatening their children's stability, destroying their retirement plans. I listened. I didn't argue. I didn't explain. I simply told them the truth in one sentence. I never sold the land. Some left furious. Some left quiet. A few came back later, alone, without the HOA's talking points, and asked to see proof. I showed them deeds, tax receipts, court orders. Faces changed when paper met reality. The HOA bravado. He said the board was authorized to make a generous offer. He said condemnation might be an option if I didn't cooperate, as if saying the word would somehow make it real. My attorney laughed out loud when he heard that. You can't condemn land for private housing developments, not retroactively. Not because you screwed up paperwork and hoped no one would notice. Eminent domain has limits, and this wasn't even close. I let the HOA talk themselves into corners. They proposed buying the land at pre-development prices. I declined. They proposed long-term leases with fixed rates. I declined. They proposed settlement structures that would protect homeowners while quietly absolving the board of personal liability. I declined because here's what they still didn't understand. They had built 96 homes on my land without permission. That wasn't just a title issue, that was trespass, ongoing trespass. And the law is not gentle with people who profit from that. The judge scheduled a remedies hearing. That hearing was where optimism went to die. My legal team laid out options. The court could impose forced purchase of the land at fair market value post-development, mandatory ground leases at market rates indexed to inflation, removal of structures, damages for years of unauthorized use, personal liability for board members who knowingly proceeded despite legal warnings. The HOA's attorneys tried to argue equity. They said innocent families would suffer. They said the board acted in good faith. They said no, one could have predicted this outcome. The judge looked at the emails again. Good faith doesn't include phrases like push it through before he notices. The ruling that followed was surgical. The aap half koshik hota hai. The aap half koshik hota hai. The aap half divided residential property. They were also ordered to pay back use damages for every month of occupancy since construction began, plus my legal fees. If they failed to complete the purchase within a fixed deadline, the alternative remedy would be court-supervised ground leases drafted on my terms. The number made the room go silent. The HOA didn't have that kind of money. Assessments went out within days. Special assessments, massive ones. Homeowners panicked. Some blamed me. Some blamed the board. Lawsuits erupted inside the community like brush fires. Residents sued the Ahatada Ek coverage, citing fraud exclusions. Board members resigned one by one, some after consulting criminal defense attorneys. The president held on the longest. Pride will do that to a person. In the middle of all this chaos, something unexpected happened. A few homeowners approached me directly, not as adversaries, but as neighbors. They asked if I would consider individual ground leases instead of a bulk HOA solution. They wanted stability, predictability, something they could show their banks. I told them I would consider it under one condition. They would have to leave the HOA. That idea spread fast. Within a month, nearly a third of the residents had filed to withdraw, triggering another cascade of legal headaches for the association. The HOA's leverage evaporated, their unity fractured. Their authority collapsed under the weight of their own shortcuts. Eventually, the board voted to dissolve. What remained of the HOA sold what assets it could, liquidated reserves, and came back to the table with humility, where arrogance used to sit. The final agreement was signed quietly. No press, no speeches, just signatures and shaking hands that lasted a little too long. The land transferred. The money cleared. The court closed the case. On paper, it was over. But paper doesn't show everything. Some homes stayed, some sold at losses. Some owners moved on, angry but wiser. The development never felt the way it was advertised. The story lingered, realtors mentioned it in hushed tones. Appraisers flagged it with footnotes. As for me, I kept the remaining acreage. I restored what I could, replanted where machines had scarred the earth. I walked the property the way my grandfather once had, slow and deliberate, feeling the shape of the land settle back into something familiar. Power isn't loud. It doesn't announce itself. It waits. It documents, it lets people show you exactly who they are before it. And sometimes, the strongest move you can make is simply letting someone finish what they should never have started. Time did what it always does after a legal firestorm. It cooled things down, but it didn't erase the scars. The development settled into an uneasy normal. The streets were still clean. Lawns were still trimmed. Kids still rode bikes in the evenings, but the confidence that once hung over the place like a sales brochure was gone. People knew now, really knew, that paperwork mattered more than promises, and that authority without ownership was just theatre. I thought my role in the story was finished. I was wrong. About 6 months after the land transfer finalized, I received a notice from the county planning office. Ruchi, they said, a compliance review. During the HR rapid construction phase, several zoning variances had been temporarily approved under the assumption of unified ownership. With the land ownership clarified and the HOA dissolved, those variances no longer applied automatically. In plain English, the development was out of compliance. Setbacks, drainage easements, road widths, stormwater runoff calculations that had been waved through because the county believed one entity controlled the entire parcel. Now each lot sat on land that had changed hands under court order, and the legal fiction that made everything neat and tidy had collapsed. The county didn't care about the drama. They cared about liability. Inspectors showed up, clipboards came out, red tags followed, not on homes yet, but on shared infrastructure. Retaining walls built, just infrastructure. Retaining walls built, just inches over allowed boundaries. Drainage channels that cut across what had once been my pasture without recorded easements, a private road section that technically crossed my remaining land at a corner where no right-of-way had ever been granted. I granted access, I always did. But access is not permission, and inspectors know the difference. The county ordered corrective plans. The cost estimates were staggering. Some fixes were possible. Others weren't, not without tearing up sections of the development no one wanted to disturb. The county offered alternatives, permanent easements, revised plats, long-term maintenance bonds. All of them required a single coordinating entity. The HOA was gone. That vacuum pulled me back in, whether I wanted it or not. Homeowners started approaching me again, this time less emotional, more practical. They needed someone to sign easements, someone to coordinate with the county, someone to act as the landowner of record for the areas that didn't neatly fall into individual lots. They asked if I would step in temporarily as a managing landholder. I said yes, but not for free. We drafted agreements. Narrow, specific, time-limited. I granted easements where it made sense, denied them where they didn't, and required compensation tied to maintenance and risk. No blanket permissions, no assumptions. Every inch accounted for. The irony wasn't lost on me. They had tried to erase me from my own land, and now the entire development needed my signature to remain legally functional. The county appreciated the clarity. Inspectors stopped treating the place like a problem child and started treating it like a complicated but solvable case. Progress resumed, slowly, carefully, expensively. And that's when the former board president resurfaced. He didn't come in person this time. He sent a letter, then another, then a proposal through an intermediary. He wanted to buy my remaining acreage outright. Not for development, he claimed. For investment purposes, he said it would bring closure. I didn't even respond, because closure had already happened, just not for him. What he rewrite the ending, where he wasn't the man who gambled with 96 families' futures and lost? Land wouldn't give him that. Silence wouldn't either. A year passed, the development stabilized. Property values stopped sliding and found a new honest baseline. The county signed off on compliance. Banks relaxed. People exhaled. And then something unexpected happened. A group of homeowners formed a voluntary association. Not an HOA, no enforcement power, no architectural committees, just a shared maintenance fund and a simple charter that said, in plain language, what it could and could not do. They invited me to the first meeting. I went. We sat in folding chairs in the community center. No podium, no microphones, just people talking like adults. They asked me questions about the land, about its history, about why I hadn't stopped construction earlier. I answered honestly. I told them that sometimes the best way to let the truth surface is to let a lie stretch itself until it snaps, that if I had intervened early, the story would have been buried in settlements and NDAs, that by waiting I ensured it would be resolved in daylight with records anyone could read. Some nodded, some looked uncomfortable. But no one argued. At the end of the meeting, a woman approached me. She had moved in just before the court ruling. She said she used to think ownership was about walls and roofs. Now she knew it started underground. That stayed with me. The land itself began to heal faster than the community ever could. Grass reclaimed graded slopes. The creek found its old path again where I'd redirected runoff. Trees grew slowly, stubbornly, indifferent to human mistakes. I put the rest of the acreage into a conservation trust with limited public access. Walking trails, educational signage, no development. Ever, the irony again wasn't lost on me. The land that had been almost erased would now be protected permanently. Years later, law schools started using the case as a study, not because it was flashy, but because it was clean. Proof, patience. Consonance. I was asked once if I felt bad for letting people move into homes that would later be caught in legal chaos. I thought about it before answering. Then I said the truth. I didn't let anything happen. I simply refused to lie to save people who are already lying to themselves. Land doesn't forget. It remembers every cut, every fence, every promise made on top of it. You can ignore that memory for a while. You can build over it, sell it, market it, but eventually someone pulls the deed out in court. And when that happens, all the speeches in the world won't move a single boundary line. The last consequence arrived quietly, the way the most permanent things usually do. It didn't come as a lawsuit or a letter from an attorney. It came as a title insurance audit. About 3 years after the dust had settled, a national title insurer conducted a routine internal review of past claims and near claims. My case was flagged, not because they lost money on it, they had avoided that, but because of how close they had come. Digging deeper, they discovered something the OHA had never anticipated and the court case had only brushed against. The forged deed hadn't just been used once. The same law firm, the same development group operating under different LLC names, had used similar consolidation shortcuts in other counties. Smaller projects, fewer homes. Care outcomes. Deals where landowners folded early or accepted settlements before the truth surfaced. My case became the reference point. The pattern was undeniable. Within a year, multiple projects across the state were under investigation. Some were resolved quietly. Some weren't. Licenses were suspended. One senior partner retired early. Another faced criminal charges for filing false instruments. The former HOA president was deposed again, this time under oath in a very different room, answering questions that didn't end with a negotiated agreement. I was never called to testify. The documents spoke for themselves. Meanwhile, the development carried on in its new, humbler form. The voluntary association worked because it had limits. When disagreements arose, people handled them like neighbors instead of subjects. The absence of power-hungry enforcement did something unexpected. It made people more reasonable. Every now and then, a new family would move in, unaware of the full history. Eventually, someone would tell them. The story always changed slightly in the retelling, but the core stayed the same. Someone tried to take land they didn't own, someone else waited. The land won. As for me, I aged into the place. The trees my mother planted grew tall enough to cast real shade. The trails in the conservation area became known spots for morning walks and quiet thinking. Kids from the neighborhood learned which parts of the creek were shallow and which weren't. Just like I once had, I kept the original deed in a fireproof safe. Not because I needed it anymore, but because it felt wrong to let it out of my sight. Once a year, I'd take it out, unfold it carefully, and read the boundaries written in careful, deliberate ink. Lines drawn by people who understood that land isn't just space, it's responsibility, memory, and restraint all at once. People still ask me what the lesson is. I tell them there isn't just one. Sometimes it's that ownership beats authority. Sometimes it's that patience is louder than force. Sometimes it's that letting someone finish building their lie makes the truth impossible to ignore. But if there's one thing I know for sure, it's this: the strongest leverage you will ever have is knowing exactly what you own and being willing to wait while others prove they never did. The land is quiet now. No machines, no shouting, no meetings filled with accusations and excuses, just wind through grass, footsteps on dirt paths, and a boundary line that has finally, unmistakably, been respected. That's how the story ends. Not with a gavel or a headline, but with land exactly where it always was, and a deed that never moved at all.